Listen up, because what I'm about to tell you could completely change everything about your marriage green card application in 2026. Some of these changes, they're already happening right now, and people are getting caught completely off guard. We're talking detentions at interviews, shocking new vetting procedures, and enforcement tactics that nobody saw coming. If you're planning to apply for a marriage-based green card, you absolutely need to know what's waiting for you. Stay with me because I've gathered insider information from attorneys across the country that you won't find anywhere else. Welcome back to Dream Visa Updates. Today I'm walking you through the massive transformation happening to the marriage-based green card process. Everything I'm sharing comes directly from what we're witnessing at interviews nationwide, information from attorney associations, and reports flooding in from legal professionals on the front lines. This isn't speculation. This is what's actually happening right now. USCIS is rolling out dramatic changes for 2026, building on policy shifts that started in 2025. They stopped sending requests for evidence. They started demanding all documents up front in one complete package. They began cracking down on people who didn't submit medical exams on time. Each of these changes added layers of stress to an already difficult process. But what we've witnessed in the last 2 months is absolutely unprecedented. These new policies have one clear goal: ensure only qualified applicants get approved. But here's the shocking part. Those who don't qualify aren't just getting denied anymore. They're being placed in removal proceedings and facing deportation. This represents a fundamental shift. In the past, if someone got denied at their green card interview, the application could simply be refiled. Not anymore. Now people are being sent directly to deportation. This started about 6 months ago, and it's accelerating fast as we head into 2026. Let me break down the major changes you need to know about. First, dramatically increased fraud detection and marriage validity scrutiny. You've probably seen news reports coming out of San Diego and other locations. Immigration officials are now actively collaborating with ICE in ways they never did before. If you overstayed your visa, even though marrying a U.S. citizen typically waives that overstay at the interview, officials are doing something completely different now. They're sending messages to ICE agents saying, "We have applicants here at their interview who overstayed their visas." ICE agents then walk into the interview room at the end and detain people on the spot. This has already happened to a Navy spouse, to a mother with a 6-month-old baby, to a 75-year-old man, all detained at their interviews. These incidents just happened in recent weeks. And there's a reason this is happening. Immigration officials now have deportation quotas. When they don't meet those quotas, they collaborate with USCIS asking, "Who else can you give us to detain?" So if you overstayed your visa, even if you're going through the marriage green card process, you could potentially be detained at your interview. The rules have fundamentally changed. If you have any overstay issues, strategizing becomes critical. Should the case be filed now or later? Should it be filed in the current city, or would relocating to an area with less aggressive enforcement be better? These are the decisions applicants will face throughout 2026. Beyond the overstay trap, immigration officers are demanding much clearer proof of marriage validity. It's no longer enough to submit joint bills or show there are children together. They want extensive evidence, affidavits, and here's the kicker: they're conducting interviews with family members and neighbors after the official interview. Officers are literally going back to houses, visiting neighbors, questioning them about marriages before making their final determination. This trend is only going to intensify in 2026. Even after successfully obtaining the conditional green card and going through 2 years of providing evidence and home visits, the challenges don't end. When filing to remove conditions, USCIS is projecting significantly higher denial rates. Why? Because during that 2-year period, many couples separate, or the evidence they provide isn't considered sufficient. They're predicting denial increases of over 20% for removal of conditions cases compared to current rates. Right now, most applicants get their conditions removed without major issues. That's about to change dramatically in 2026. This means even passing the initial 2-year green card interview doesn't guarantee success when removing conditions. The solution? Increase evidence gathering. Document absolutely everything during those 2 years. Most people are in genuine marriages, but proving it can be surprisingly difficult when documentation hasn't been a priority. To avoid problems down the road, document everything continuously throughout those 2 years. Next, fee increases and form addition mandates. If the wrong form addition is used, serious consequences follow, including potential denial and deportation. Starting January 1st, 2026, major fee hikes are hitting nearly all immigration forms. If filing is in the plans, do it now. The adjustment of status form is increasing by over $500. Form I-130 is going up by over $300. roughly 20% increases across most forms and applications. Here's the critical part. If the wrong edition of even one form is used in the entire package, everything gets sent back and denied. If there's a tight deadline waiting for time-sensitive approvals, that rejection could result in receiving a notice to appear and being sent to removal proceedings. Third, processing times are getting significantly longer. Green card processing times are expected to stretch from 9 to 15 months, compared to the current 6 to 10 months. Adjustment of status cases could reach wait times exceeding 15 months. More people are being called for mandatory interviews. House visits are increasing. Notices of intent to deny are projected to jump by 25%. And requests for evidence are coming back. So when cases are filed, they need to be done correctly from the very beginning. Don't leave out any documents because getting a request for evidence will delay cases even further. Fourth, security vetting and the public charge rule are being expanded. In 2026, expect increased security vetting, including mandatory social media reviews, biometrics and rebiometric checks, and AI-driven tools to vet applicants. These often result in delays and potential denials. The expanded public charge rule will look back 5 years to identify anyone who used public benefits. USCIS officers will use these factors against applicants. All of this takes effect after February 2026. So what does all of this mean when put together? We're witnessing a deliberate push toward reverse migration. The government doesn't want people to immigrate. They want to remove as many people as possible and make life increasingly complicated for immigrants. If going through the immigration process right now, don't panic. With proper planning, understanding what they're looking for, and knowing how to respond to these challenges, things will be fine. If there's a strong, genuine case, this is just a storm to weather together. Don't be scared. Don't be intimidated. These changes are coming, and now you know about them. Now preparation is possible. Drop a comment below, and let me know what you think. Share this video with anyone who needs to know. Thanks for watching Dream Visa Updates. See you in the next one.